Welcome back to the deep dive.
It's good to be here.
When we think about the law or when we see it on TV, we're always looking at the shiny exterior,
Oh, absolutely. The drama.
the heated arguments, the surprising witnesses, the gavel banging, all that theatrical stuff. But today,
Today is different.
today we are putting on the grease-stained coveralls. We are popping the hood and climbing right into the engine room of the American legal system.
It's a fascinating place to be, a little greasy, like you said.
We're talking about the mechanics of the courtroom.
You're right about that TV perception.
Yeah.
You think of the law as a story, the narrative of the case.
Right. Who's the good guy? Who's the bad guy?
Exactly. But the reality is that the outcome of a trial is often decided not by who has the better story, but by these really strict, almost mathematical rules that govern how the whole machine runs.
The gears and the pulleys.
That's the perfect analogy. The federal rules of civil procedure. And specifically, we're diving into the rules that control the trial itself, and then that chaotic period right after a verdict comes down.
And I think that's the part that would surprise most people. We all have this sort of simplified movie version of a trial in our heads.
Mm-hmm.
You know the beats. The jury sits there looking very serious. They listen to some speeches. Someone has a breakdown on the stand and yells, "I did it!"
Right, the dramatic confession.
And then the jury comes back, says guilty or liable, and the credits roll. End of story.
It's a great narrative arc, but it misses probably 90% of the actual procedural warfare that goes on.
Warfare is a good word for it. We've been reading through this massive stack of these rules. Specifically, we're focusing on what's called Rule 38 through Rule 68.
The trial and post-trial rules.
And the biggest takeaway for me was that the trial doesn't end when the jury speaks. In fact, some of the most dangerous traps for a lawyer happen after the verdict is read.
Or even before the jury is seated. Or honestly, before the lawsuit is even fully drafted. The whole process is lined with these little tripwires.
So our mission today is to decode these rules. We want to translate this dense, legalese into something you can actually visualize.
Yeah, to show you how a trial actually functions, step by step, and where all the bodies are buried.
Because if you don't know where those traps are...
You're going to fall into them. It's almost guaranteed.
Okay, so let's start at the very beginning. The jury. In the American imagination, the jury is everything, right? It's the voice of the people. But who actually gets one? Is it automatic?
That is the fundamental question. And to answer it, you have to look at the foundation, the Constitution.
The Seventh Amendment.
Specifically the Seventh Amendment, which Rule 38 basically just points back to.
And it says it preserves the right of trial by jury.
The phrase is preserved inviolate. That language is heavy. It's intentional.
Inviolate, meaning sacred. You can't mess with it.
Exactly. But, and here is the first massive, massive nuance that trips people up. Not every case gets a jury.
Right. And this brings us to a distinction that feels like it belongs in a history textbook, but it actually controls what happens in a federal courtroom today.
It really does.
The difference between law and equity.
It sounds like a philosophy class, doesn't it?
Uh-huh.
Law versus equity.
It sounds like a class I would have definitely slept through. So explain why this matters to you, the listener, who just wants to sue someone.
It matters because your constitutional right to a jury hinges on this ancient distinction. To get it, you really have to go back to medieval England. Way, way back. You basically had two entirely separate court systems. You had the court of law and you had the court of equity.
So like two different buildings, two different judges.
Often, yes.
Yep. Oh.
Two different sets of rules. If you went to the court of law, you were asking for one thing: money.
Damages.
Compensation. Right. And in that court, the court of law, you had the right to a jury of your peers.
Okay, so a simple rule of thumb. Money equals jury.
That's the starting point. But what if money couldn't fix your problem?
What do you mean?
Let's say you needed the king to order your neighbor to stop dumping trash on your lawn. Money for the damage already done is nice, but it doesn't stop him from doing it again tomorrow.
I want him to stop.
You want an order, an injunction. For that, you went to the court of equity. This was run by the king's chancellor, who was sometimes called the keeper of the king's conscience.
And I'm guessing the keeper of the king's conscience didn't really care what a jury of 12 farmers had to say about it.
Not in the slightest. In equity, the judge decided everything. There was no jury. It was all about fairness and specific orders, not just calculating a bill for damages.
Okay, so fast forward to today. We don't have a king's chancellor. We just have federal judges.
Correct. In 1938, the federal rules merged the systems. So now you have one judge, one courtroom for all claims.
Oh, that.
But and this is the crucial part. The Constitution says the right to a jury is preserved. It locks in the rights as they existed back in 1791.
So to figure out if I get a jury today, I have to use a sort of legal time machine to see what would have happened in 1791.
In a way, yes, we have to look at the nature of the relief you're asking for. Let's use a hypothetical to make this stick.
Okay.
Let's say you, the listener, have two legal problems. Problem A, you were in a car crash, someone ran a red light, smashed up your car, and now you have medical bills and repair bills.
Okay, that's pretty standard. I want money to pay for the damage. I want compensation.
Precisely.
Yeah.
In the eyes of the court, that is an action at law. You are seeking monetary damages. Because of that, you have a constitutional right to a jury.
Money equals jury. Okay, I've got that. Now, what's problem B?
Problem B is different. Let's say your neighbor is building this massive, ugly fence that's going to completely block your view of the ocean.
I hate this neighbor.
He's the worst. It violates all the HOA rules. It's hideous. You don't necessarily want money. You just want him to stop building it.
I want an injunction. I want the court to order him to put down the hammer and tear down what he's already built.
Exactly. That is an action in equity. You're asking the court to compel someone to do something based on fairness. Historically, that was the chancellor's job.
So in federal court today, for that kind of claim, I get a judge, no jury.
Generally speaking, that's right.
Okay, so money equals jury. Injunction equals judge. But life is never that clean, is it? What happens if my case has both? I want money for the roses my neighbor already trampled while building the fence, and I want an injunction to stop him from finishing it.
And now you've hit on the mixed case scenario. And for a long, long time, this was a strategic nightmare for the courts.
Why? It seems pretty simple. Just let the jury decide the money part and then let the judge decide the fence part.
But think about the underlying facts. To decide the money claim for the roses, what does the jury have to decide?
They have to decide if the neighbor trespassed on my property.
Right. And to decide whether to grant the injunction to stop the fence, what does the judge also have to decide?
The exact same thing. Did he trespass?
Exactly. You have two different decision makers, a judge and a jury, answering the same core factual question. And what happens if they disagree?
Oh, I see the problem now.
What if the judge decides first, says no trespass, and throws out your injunction claim? He has effectively killed your claim for the roses before the jury even gets to sit down.
He stole the jury's job.
He deprived you of your Seventh Amendment right. And this was a massive problem, often called the race to judgment, until the Supreme Court finally settled it in a famous case called Beacon Theaters.
I love that name, Beacon Theaters. Sounds like an old movie palace. So what's the rule now?
The rule is strictly chronological, and it's designed to protect that jury right above all else. The jury decides the legal claims, the money stuff first.
Ah, okay. So the jury sits down, they hear all the evidence about the trampled roses, and they decide if the neighbor is liable.
Exactly. They are the first to find the facts. They say, yes, he trespassed, and yes, he owes you $500 for the roses. And here is the key constraint. After that, when the judge steps in to decide the equitable claim, the injunction about the fence, the judge is bound by the factual findings the jury just made.
Oh, that's really interesting. So the judge can't say, well, the jury said he trespassed, but you know what? I'm smarter than them and I disagree.
Nope, cannot do it. The jury's version of the facts becomes the reality of the case for all purposes. The judge's hands are tied on the facts.
So the jury's decision on a relatively small money claim can actually control the outcome of the much bigger injunction claim.
It's often called the tail wagging the dog. The jury's finding on the legal tail wags the equitable dog.
That makes the jury incredibly powerful, even in these mixed cases. It basically means the jury is the ultimate fact finder, period.
It does. Which is why the next rule we need to talk about is so terrifying.
Why?
Because getting that incredibly powerful jury isn't automatic.
Right. Rule 38B. This feels like a gotcha rule.
It is the definition of a gotcha rule. It is a trap that snags rookie lawyers and sometimes even veteran lawyers all the time. You have this inviolate constitutional right to a jury, but
You have to ask for it.
you have to demand it.
And not just out loud.
No, in writing.
Yeah.
And you have to do it within 14 days of the last pleading directed to the issue.
Let's break that down. Last pleading. What does that usually mean?
In a simple case, it means the defendant's answer to the complaint.
So I file my lawsuit. The other guy files his answer. A 14-day clock starts ticking right then.
Exactly.
And if I'm busy or I just assume, hey, this is America, of course I get a jury, and I let 3 weeks go by.
You have waived the right. It's gone. Poof.
That is wild. You can lose a fundamental constitutional right because you missed a 2-week paperwork deadline.
Procedural waiver is a harsh mistress. The system needs certainty. It needs to know early on, are we booking a jury room and summoning citizens for this, or are we just scheduling time in the judge's chambers? If you don't speak up, the system assumes you don't want it.
So, lesson number 1 for you, the listener. If you want a jury, write it down immediately, put it in your complaint, tattoo it on your forehead.
Please, just put it in a complaint. It's the safest way.
Okay, so let's say we did it right. We filed the paper, we demanded our jury. Now we actually have to pick them.
Yes, the process of voir dire.
Which literally means...
To speak the truth. It's the process of questioning potential jurors to see if they can be fair.
In the movies, this part is always super dramatic. The lawyer is walking up and down the row, staring into the souls of the jurors, asking these deep psychological questions.
It's usually a bit more mundane than that, but the stakes are just as high.
So what are the actual rules here? Let's start with the numbers. How big is this jury?
Well, first, in federal civil court, under Rule 48, the jury has to be between 6 and 12 people.
That feels small compared to the criminal cases where we always hear 12 angry men.
It can be 12, but it can also be as few as 6. And here's a major difference from what you might see in state courts or on TV. In the federal system, there are generally no alternates.
Wait, really? So if juror number 4 gets the flu halfway through a 3-week trial?
Well, the rule says everyone who is selected participates in the verdict unless they're dismissed for good cause. So if you start with, say, 8 jurors and 1 gets sick,
you just finished with 7.
Exactly. The trial just proceeds with the remaining jurors as long as you don't drop below 6.
So if you start with 6 and 1 gets sick, then you have a problem.
Then you have a big problem. But the idea is that everyone in the box is a full participant from the start. No one is just a backup.
Got it. So everyone in the box is in the game. Now let's talk about getting kicked out of the box. The challenges. This is where the real strategy comes in.
It's pure strategy. And there are 2 main ways to get rid of a potential juror. The first is the challenge for cause.
This is what it sounds like. There's a legitimate legal cause why this person cannot be fair.
Right. Let's say a potential juror is the defendant's brother.
Obvious bias.
Or they own stock in the plaintiff's company. Or they just stand up during questioning and announce, I hate all corporations and I will always vote against them no matter what the evidence is.
Okay, that is actual stated bias. So you challenge for cause.
And the judge rules on it. If the judge agrees that the person is biased, they're gone. And the key here is that you have unlimited challenges for cause.
You can strike as many people as you need to, as long as you can prove they can't be impartial.
Exactly. If the whole jury pool happens to be the defendant's family reunion, you can, in theory, strike them all.
But then you have the other kind, the peremptory challenges.
These are the ones everyone's heard about. These are the freebies.
The get-out-of-jail-free cards for jurors you just don't like.
Essentially, in a federal civil case, each side usually gets 3. A peremptory challenge means you can reject a juror without stating any reason at all.
So, I just don't like the way he looked at me, or she's wearing a bow tie and I don't trust people who wear bow ties.
You don't even have to say that out loud. You just say, Your Honor, the defense excuses juror number 5. And they're gone. It allows lawyers to play their hunches.
Jury consultants make millions of dollars advising on this, right?
Oh, absolutely.
Yeah.
Strike the engineer, they overanalyze.
Yeah.
Strike the artist, they're too emotional. It's a whole industry built on stereotype.
And this is a huge, but there's a constitutional limit here, too. You can't just strike anyone for any reason.
No, you can't. And this is where we get into some really important Supreme Court cases.
We're talking about Edmondson and J.E.B.
Yes. For a long time, lawyers could use these strikes to shape the jury's racial makeup. If you had a black defendant, the prosecutor might use all their peremptories to remove black jurors.
That's awful.
It is. So the Supreme Court, first in criminal cases and then extended to civil cases in Edmondson, said you cannot use a peremptory challenge to discriminate based on race.
And how does that work in practice? How do you prove it?
Well, if the other side sees a pattern, say, you've used all 3 of your strikes on the only 3 Hispanic jurors in the pool, they'll object. It's called a Batson challenge.
And then what?
Then the burden shifts to you. You have to stand up and give a race-neutral reason for those strikes. And it can't be something flimsy. If the judge thinks your reason is just a pretext for discrimination, they'll disallow the strike.
And the J.E.B. extended this to gender as well.
Correct. J.E.B. was actually a paternity case where the state used almost all its strikes to remove men from the jury.
Assuming they'd be more sympathetic to the alleged father.
Exactly. And the Supreme Court said no. You can't use the power of the court system to enforce gender stereotypes.
So peremptory implies absolute or no questions asked, but the reality is it's no questions asked unless we think you're being a bigot.
That's a perfect way to put it. It protects the integrity of the process and the dignity of the jurors themselves.
Okay, let's do a quick recap of this first part because we've covered a lot of ground.
Let's do it.
Money claims get a jury. Injunctions get a judge. If you have both, the jury goes first, thanks to Beacon Theaters.
Right.
You absolutely have to ask for that jury in writing within 14 days, or you lose the right forever.
The biggest trap.
And when you're picking that jury, you have unlimited strikes for actual bias, but only 3 freebie strikes, and you can't use those to discriminate based on race or gender.
A perfect summary. The machine is set. The jurors are in the box. Now the real show begins.
So we have our jury. Let's say it's 8 people. They sit through the whole trial. They hear all the evidence. They struggle to stay awake during the expert testimony.
We have all been there.
And now they march back into that little room to decide our fate. This is part 2. Inside the black box.
The deliberation room. It is, I think, the most secretive place in the American government. Even the president has the Secret Service in the room with him. The jury is completely alone.
So what are they actually allowed to do in there? Can they bring their notes in with them?
Yes, absolutely. Juror note-taking used to be kind of controversial.
Yeah.
But now it's standard. They bring in their notes and they bring in the exhibits.
So the photos, the contracts, the actual gun, or the broken car part if it was admitted into evidence.
Everything that was formally admitted. They can re-examine it all. But they are supposed to be hermetically sealed from the outside world.
Which brings up the big question in the modern age. What about their smartphones?
The ultimate temptation.
What if a juror thinks, I wonder what this defendant's company's stock price is doing today? Or let me just look up that street intersection on Google Maps to see if that witness was lying about the stop sign.
That is strictly forbidden. That is the cardinal sin of jury service.
Why?
Because the lawyers never got a chance to cross-examine Google Maps. If a juror brings in outside information, they are essentially becoming an unsworn witness that no one can question. It breaks the entire system of evidence. It's immediate grounds for a mistrial.
Okay, so they can only use what was presented in court. Now, when they come to a decision, I always just thought it was, we find for the plaintiff. But the rules mention a few different types of verdicts. Why complicate it?
Well, that simple one you mentioned is called a general verdict. Plaintiff wins. Here's $100,000. Done. It's clean, but it hides a lot. We don't actually know how they got to that conclusion.
We don't know if they decided the defendant was negligent or maybe they just didn't like his tie.
Exactly. So sometimes the judge or the lawyers want to make sure the jury isn't just flipping a coin or acting purely on emotion. And for that, they can use a special verdict.
How does that work? Is it still a verdict?
It's more like a standardized test. The jury doesn't say who wins or loses. They just answer specific factual questions on a form.
Like what?
Question 1. At the time of the accident, was the traffic light facing the defendant red? Yes or no? Question 2. Was the plaintiff exceeding the speed limit? Yes or no? Question 3. If you answered yes to both, what were the plaintiff's total medical damages?
And then what happens?
Then the jury is done. The judge takes that answer sheet and applies the law to those facts to determine who wins.
That seems like a really smart way to keep the jury focused on the facts rather than their feelings about the parties.
It is, but it can be risky. What if the jury's answers are inconsistent? What if they answer the light was green, but also the defendant negligently ran the red light?
They've contradicted themselves.
Exactly. And then you have a total mess. So there's also a hybrid, a general verdict with special interrogatories. That's where they declare a winner, but they also have to answer the key questions to show their work.
It's like a way to audit the jury's logic.
That's a great way to put it. It's an audit.
Now, does the jury have to agree? In criminal trials, we always hear it has to be unanimous. What about a federal civil trial?
Same rule. Unless the parties agree to something else in advance, which they rarely do, a federal civil verdict must be unanimous.
Every single person has to be on the same page.
Yes. And to make sure that's really what happened, to ensure that the foreperson isn't just, misrepresenting the room, there's a procedure called polling the jury.
Ah, this is the dramatic moment after the verdict is read.
It can be incredibly tense. The foreperson reads the verdict. We find for the plaintiff. The losing lawyer, desperate for any lifeline, stands up and says, "Your Honor, we request that the jury be polled."
And the judge asks each juror, one by one,
Juror number 1, is this your verdict? Juror number 2, is this your verdict? All the way down the line.
Has anyone ever actually said no in that moment?
It's rare, but it absolutely happens. Imagine the peer pressure in that deliberation room. You might have a juror who just wanted to go home, so they caved and said, fine, I agree.
But then they're in open court, looking the defendant in the eye.
And the judge asks them directly. And sometimes they break. They say, no, Your Honor, that is not my verdict.
And if they say no, what happens?
Chaos. The verdict is invalid. The judge either has to send them back to the deliberation room to keep arguing, or, if it seems hopeless, declare a mistrial and everyone has to start over from scratch.
Wow. Talk about a last-minute plot twist.
Yeah.
Now, let's say they all say yes. They're discharged. That's it, right? The verdict is set in stone.
Mostly. But this brings us to one of the most controversial and I think philosophically difficult rules in the whole book, Rule 606B.
Which is about?
Impeaching the verdict, which is a fancy way of saying trying to get the verdict thrown out based on what happened in the jury room.
Okay.
The general rule is what's called the rule of silence. A juror cannot come forward later and testify about what happened during deliberations in order to overturn the verdict.
So if a juror comes out the next day and tells a reporter, yeah, I voted for the plaintiff because I just didn't like the defendant's face, or we didn't understand the judge's instructions at all, so we just guessed.
Generally, the court will not hear that testimony. The verdict stands.
That sounds insane. If they admitted they just guessed, or that they ignored the law entirely, how can we let that stand?
It's a very deliberate policy choice. The system prioritizes finality over perfection.
What do you mean?
If we allowed lawyers to go around interrogating jurors after every single trial, trying to find some flaw in their logic or their reasoning, no verdict would ever be safe. Defeated parties would harass jurors forever. It would completely destroy the jury system.
Okay, I see that. But there has to be a line. What if the jurors were doing drugs in the deliberation room? What if someone was bribed?
And that's where the exception in Rule 606B comes in. It's a very narrow exception. It allows testimony about extraneous prejudicial information or outside influence.
Go back to the smartphone example.
Right. If a juror comes forward and says, juror number 6 went to the crime scene last night on his own, measured the tire marks himself, and brought those measurements into the deliberation room.
That's extraneous information. It's evidence that was never presented in court.
Exactly. The court can hear testimony about that. Or if someone bribed a juror, that's outside influence. The court can hear about that too.
But what about internal stuff? If the jurors were drunk, or they were trading votes, I'll vote with you on liability if you vote with me on damages.
The Supreme Court has actually held, in cases like Tanner v. United States, that the court usually won't intervene for that. Drunkenness, drug use, misunderstandings, those are considered internal to the process.
That is a fascinating, if slightly disturbing line to draw. Internal dysfunction is ignored, external contamination gets fixed. It really protects the black box nature of the jury.
It does. It basically says that once that door is closed, the process inside is sacred, flaws and all.
Okay, so the jury has spoken, the verdict is read, but, and here is where the mechanics get really, really technical, the judge still has a say. The judge isn't just a referee. Sometimes they can step in and stop the game entirely.
This is part 3 of our dive, Judgment as a Matter of Law, or JOL.
This used to be called a directed verdict, right? I hear lawyers use that term all the time.
They do. Many still call it that in casual conversation. But the official term in the federal rules is judgment as a matter of law under Rule 50.
And this is basically the judge telling the jury, stop, you are wrong, go home.
Or, maybe more accurately, there is no need for you to even decide this, because the answer is mathematically obvious.
What's the standard for a judge to do that? They can't just do it because they disagree with the jury's conclusion, can they?
No, absolutely not. The bar is stratospheric. A judge can only grant a JMLL if no reasonable jury could find for the other side.
No reasonable jury. That sounds like a tough standard to meet.
It is. It means the evidence for one side is so lopsided or so completely non-existent that there is literally nothing to deliberate. And the Supreme Court, in a case called Reeves v. Sanderson Plumbing, clarified that the judge has to view all the evidence in the light most favorable to the non-moving party.
So if I'm the judge and I'm thinking about throwing out the plaintiff's case, I have to assume that everything the plaintiff and their witnesses said is 100% true.
Essentially, yes, you have to give them the benefit of every possible doubt. And this is crucial. The judge cannot weigh credibility.
Meaning what?
If plaintiff's witness A says the light was red and defendant's witness B says the light was green, the judge cannot say, Well, witness A seemed kind of sketchy and was sweating a lot, so I don't believe him. That's the jury's job. The judge can only step in if the plaintiff had no witness at all to say the light was red.
Okay, so the legal standard is high, but the procedure, this is the trap you mentioned at the very beginning, the two-step procedural trap.
This is, I would argue, the single most dangerous procedural minefield in all of trial practice. It involves two parts of the same rule, Rule 50A and Rule 50B.
Okay, walk us through it step by step.
Step 1 happens during the trial, before the case ever goes to the jury. This is the Rule 50A motion. Let's say you're the defense lawyer. The plaintiff presents their entire case, all their witnesses, all their documents, and then they rest. You, as the defense lawyer, stand up and say, Your Honor, I move for judgment as a matter of law. The plaintiff has presented zero evidence that my client was even at the scene of the accident. No reasonable jury could find for them.
Right. And let's say the judge says, nice try, counsel, but I think there's just enough here. I'm going to let the jury decide. Motion denied.
Okay, fine. The motion is denied. So the trial continues, it goes to the jury, and the jury deliberates. And, surprise, the jury comes back and finds for the plaintiff. They ignore the lack of evidence and award $1 million.
The defense lawyer must be furious. He knows there was no evidence. So now he wants to go back to the judge and ask him to fix the jury's mistake after the verdict. This is step 2.
Correct. This is the renewed motion for judgment as a matter of law under Rule 50B. It used to be called a JNOV judgment non obstante veredicto, which is Latin for judgment notwithstanding the verdict. You have 28 days after the verdict to file this.
So you go back to the judge and say, okay, judge, the jury got it wrong. Now will you please overrule them?
Yes. But here's the catch, the trap. You are legally forbidden from making the Step 2 post-verdict motion unless you made the Step 1 pre-verdict motion.
Wait, hold on. Let's play that out with a different scenario. I'm a defense lawyer. I sit there. I listen to the plaintiff's whole case. I think it's absolute garbage. I think they proved nothing.
You're feeling very confident.
I'm so confident that I don't even bother making a motion. I think, why waste the judge's time? The jury will see this for what it is. So I stay silent and let it go to the jury.
A risky move.
Then the jury comes back and says, pay the plaintiff $1 million. I am shocked. I run up to the judge and say, Judge, this is insane. There was no evidence. You have to fix this.
And the judge will look at you and ask one question. Counsel, did you make a Rule 50A motion before the case was submitted to the jury?
And I say no, because it was so obvious it was a garbage case.
And then the judge says, too bad. Motion denied. You pay the $1 million.
That seems incredibly, fundamentally unfair. I lose $1 million on a baseless case because I didn't say the magic words at halftime.
It feels harsh, but there's a good reason for it. It's to prevent what's called sandbagging.
Sandbagging.
The court doesn't want you to hide your argument, lie in the weeds, wait to see if you get a lucky verdict from the jury, and then only complain if you lose.
Ah, I see.
If there's a fatal flaw in the other side's case, like they forgot to introduce a key piece of evidence, you have to point it out to them before it's too late for them to fix it.
You have to give them a chance to cure the defect.
Exactly. If you make the motion in Step 1, you put them on notice. They might say, oh my gosh, he's right. I forgot to put the contract into evidence. Your Honor, may I reopen my case to fix that? But if you stay silent, you've robbed them of that chance. So the law says, speak now or forever hold your peace. Literally.
And courts are strict about this.
Ruthless. There are famous cases on this.
Yeah.
If you didn't make a 50A motion, you cannot make a 50B motion. Game over. It is a malpractice trap that has ruined careers.
That is terrifying. Okay, quick recap of part 3. To get a judge to overrule a jury, the evidence has to be so bad that no reasonable person could have voted that way.
Right.
And to challenge a verdict after it's read, you absolutely must have challenged the evidence during the trial first. You cannot wait and see what the jury does.
You cannot sandbag the court.
Okay. Now, let's say you did everything right. You made the motion, but the judge denied it, and the jury still ruled against you. Or maybe something else just went horribly wrong. This leads us to part 4, the do-over. The motion for a new trial.
This is Rule 59. This is the system's safety valve.
A JMLL is about winning outright. It's saying, the jury was wrong, therefore I win. A new trial motion is different. It's just asking to reset the game.
Exactly. The judge isn't declaring a winner. They're just saying, something went so wrong here that the result is unjust. Let's do this all over again with a new jury.
And what kind of things would be grounds for that?
The overarching theme is to prevent a miscarriage of justice. So it could be a major error at trial. Maybe the judge realizes they made a huge mistake in the legal instructions they gave to the jury.
Okay. What else?
or there's newly discovered evidence.
And that has to be evidence you couldn't possibly have found earlier, right? Not just evidence you were too lazy to look for.
Correct. It has to have been truly hidden. Also, prejudicial misconduct. If a lawyer was screaming at the jury or a juror was caught lying during selection. And finally, if the verdict is against the clear weight of the evidence.
Wait, that sounds a lot like the James All standard again.
It's similar, but the standard is much lower. For a new trial motion, the judge can act like a 13th juror. They can weigh the evidence a bit more.
So they can say.
They can say, look, technically there was some evidence, so I can't grant a JMOL and end the case. But this verdict feels deeply wrong. I think the witnesses were lying. It's fishy. Let's just do it over.
It's a much softer remedy. Now let's talk about money. Because sometimes the jury gets a winner right, but the dollar amount they award is totally, totally bizarre.
This is where we get into the battle of remittitor versus additor. And this is where federal court gets really quirky.
Okay, remittitor, that sounds like remit, or to give something back.
That's exactly what it is. Suppose the jury finds for the plaintiff who suffered a broken finger, a painful injury to be sure, but the jury awards $10 million.
That's excessive. Unless it's a world-famous concert pianist's finger.
It's irrational. It shocks the conscience. The judge can use the tool of remittitor. The judge issues an order that says, plaintiff, this $10 million award is absurd. You have a choice.
A choice.
Either you accept a reduced award, say $50,000, or I am ordering a brand new trial on all issues.
So it's a threat, basically. Take the lower, more reasonable amount, or we start over from scratch and you might get nothing next time.
It's a choice. And the Supreme Court has said you have to give the plaintiff that choice. A judge can't just unilaterally lower the number because that would violate the plaintiff's right to have a jury determine their damages.
Okay, so that's for when the award is too much money. What about the opposite? What if the jury is just mean and stingy, they find the defendant is clearly liable, but they only award $1 in damages?
This is where you would want to use additor, adding to the verdict. And here is the quirk. In federal court, additor is unconstitutional.
Wait, really? The judge can lower an excessive award with remittitor, but they can't raise an inadequate one with additor.
Correct. The Supreme Court decided this a long time ago. They held that for a judge to add money that a jury never actually awarded is a clear violation of the Seventh Amendment. It's the judge inventing a fact, the amount of damages that the jury never found.
That feels weirdly asymmetrical. Why is subtracting money okay, but adding money isn't?
It's a historical anomaly, but it's the law. The result is, if the award is shockingly low, a federal judge's only option is to order a complete new trial.
Yeah.
They cannot just say, that's not enough, make it $50,000.
That is a detail that could absolutely ruin a lawyer's day if they didn't know it. You go in expecting the judge to top up your $1 verdict, and instead you get thrown back into a whole new trial.
Exactly. You might have been better off with the $1.
Okay, moving on to the end game. The dust has settled. We have a final judgment. Part 5. Who pays for all this?
This brings us to Rule 54. And the first thing to understand is the crucial distinction between costs and fees.
I thought those were basically the same thing.
In common language, maybe. In the law, they are very, very different. Costs refer to the basic administrative expenses of the lawsuit.
Like what?
Filing fees you pay the clerk, the cost of serving the summons, the cost of printing transcripts of depositions, the overhead of the lawsuit itself. Rule 5040 says that the winner, the prevailing party, usually gets their costs paid by the loser, almost automatically. It's the standard practice.
But fees, that means attorney's fees, the lawyer's hourly rates, that's the really big money.
Exactly. And the default rule in the United States, called the American Rule, is that each side pays their own lawyers, win or lose. Unless a specific statute says otherwise, like in many civil rights cases, or there was a contract between the parties that says the loser pays the winner's fees. If you want attorney's fees, it's not automatic. You have to file a separate motion within 14 days of the judgment proving you're entitled to them.
Okay. But there is a mechanism to force the other side to think hard about fees and costs, right? We've been talking about the trial like it's this pure search for truth, but we all know that most cases never get that far.
95%, 98% of cases settled before trial.
And even settlement has a mechanic. It's not just two people arguing in a hallway. There is a weaponized rule for encouraging settlement, isn't there?
There is. It's Rule 68, the offer of judgment. This is one of the coldest, most mathematical, and most strategic rules in the entire book. It turns the lawsuit into a high-stakes poker game.
I love this rule because it's so clever. Walk us through a scenario.
Okay, you're the defendant. You know you might have some liability, but you think the case is really only worth about $20,000. The plaintiff, however, is demanding $1 million.
They're dreaming of a yacht. They're being unreasonable.
Completely. So at least 14 days before the trial is set to start, you serve a formal, written Rule 68 offer of judgment. You say, I will give you $50,000 right now to make this go away.
That's a premium. That's more than you actually think the case is worth.
It is. But you want peace, and you want to avoid the risk and expense of trial.
Sure.
Now, the plaintiff has a very difficult decision to make.
They have to do the math.
Right. They can accept it, and the case is over. Or they can reject it and go to trial. Let's say they reject it. They say, no, I want my $1 million.
Okay, so we go to trial.
We go to trial, and the plaintiff wins. The jury comes back and says, we find for the plaintiff in the amount of $40,000.
Okay, so they won. They beat me in court. They proved their case.
They won the battle, but they lost the Rule 68 war. Because the $40,000 they won is less than the $50,000 you offered them.
And the consequence for that isn't just shame, it's financial.
It's brutal. Because they failed to obtain a judgment more favorable than your offer, the plaintiff now has to pay for your costs that were incurred after the offer was made.
And costs can be substantial, right?
In a complex case, they can be tens of thousands of dollars, deposition transcripts, expert witness fees, court reporter fees, all of that.
So they could win the verdict, get a check from me for $40,000, but then have to turn around and write me a check back for $15,000 in my costs.
Precisely. It can completely wipe out their victory. It forces a plaintiff to look in the mirror and ask, am I really sure I can beat that $50,000 offer at trial? It removes emotion and forces a cold, hard risk assessment.
It effectively punishes you for wasting the court's time when a perfectly good deal was already on the table.
That's exactly its purpose.
We're heading into the final stretch here. Part 6 covers some other trial styles and procedural moves. We've talked a lot about juries, but what happens when there is no jury? A bench trial.
A bench trial, or trial by court, is where the judge is both the finder of fact and the decider of law. But Rule 52 requires the judge to show their work. They must write out separate findings of fact and conclusions of law.
So they can't just write a one-line order saying plaintiff wins.
No, they have to lay it all out. Fact 1, the light was red. Fact 2, the car was speeding. Conclusion of law. Based on these facts, the defendant was negligent. This allows the appeals court to clearly see and review the judge's logic.
That makes sense. Now, what about efficiency? Sometimes you have 10 different lawsuits all filed about the same plane crash. Does the court have to try that same case 10 times?
No, thank goodness. Rule 42 gives the court the power of consolidation. If cases pending in the same district share common questions of law or fact, the judge can smash them all together into one big trial to save time and money.
And it works the other way, too.
Yes, the same rule allows for separate trials, which is often called bifurcation. Sometimes it makes sense to split a single case into pieces.
Give me an example.
A common one is to try liability first. Did the defendant do it? If the jury comes back and says no, we all go home. The trials is over.
And if they say yes?
Then we have a second separate mini-trial, maybe with the same jury, just on damages, how much money is owed.
That saves a ton of time if the answer on liability is no. You don't have to waste a week bringing in all the doctors to talk about the extent of the injuries if the guy wasn't even liable in the first place.
Exactly. It avoids prejudice and saves enormous resources.
One last tool in the toolkit. This one sounds aggressive. Prejudgment attachment. Rule 64.
It is extremely aggressive. Imagine you're suing someone who you know is a total scam artist. You're worried that by the time you finally win the trial a year from now, he will have moved all his money to an offshore account in the Cayman Islands.
So I'll win a very nice piece of paper saying he owes me $1 million, but his bank account will be empty.
The judgment will be worthless. Prejudgment attachment allows you, in certain circumstances, to ask the court to seize the defendant's property or freeze their assets at the very beginning of the case before you've even won.
That seems like a massive violation of due process. You're taking his stuff before he's even been found liable.
Which is why the legal bar for it is incredibly high. You have to show a strong likelihood that you're going to win the case, and you usually have to post a large bond to cover the defendant's damages if you're wrong. It's a rare emergency measure.
So it's like putting a boot on the car so it can't drive away before the police even finish writing the ticket.
That's a great analogy for it. It's to make sure there's actually something left to collect at the end of the day.
Wow. From seizing assets before the trial even starts to the poker game of Rule 68 at the very end. We have really covered the full life cycle of this machine.
We have. It's a complex piece of machinery.
Let's try to bring this all together. We've looked at the gears, the levers, the safety valves, the traps. What is the big overarching takeaway here?
For me, it's that these rules aren't just bureaucracy for its own sake. They are a constant, delicate balancing act
A balancing act between what?
between getting it right and getting it done. Every rule we discussed, Rule 38, preserving the jury right, Rule 50, demanding you speak up before the verdict, Rule 606, protecting the jury's secrets, it's all trying to balance fairness with finality.
Efficiency versus perfection.
Exactly. If we wanted perfect fairness, we'd allow lawyers to interrogate jurors for weeks after a verdict. We'd let judges fix every single $1 mistake, but the system would grind to a halt and collapse.
And if we wanted perfect efficiency,
We'd have no juries at all and just let an AI decide every case in a millisecond. These rules are the messy, human, imperfect compromise that keeps the whole engine running day after day.
and for you, the listener, the next time you watch a legal drama on TV and the foreperson reads the verdict, just remember, the game is almost certainly not over. The lawyers are probably already drafting their Rule 50B motions, frantically checking their notes to see if they made their 50A motion correctly or calculating their Rule 68 costs.
The verdict is just halftime.
So I want to leave you with one final thought to chew on. We talked about Rule 606B, that strict rule that says we cannot look inside the jury room. We place an immense amount of trust in that black box. We have to assume the jury understood the law and followed it. But because of that rule, we will never truly know how many verdicts are based on brilliant legal logic and how many are based on a complete misunderstanding or a coin flip, or simply because someone in the room really wanted to get home for dinner. The system makes a choice. It chooses finality over truth. Is that a price we're comfortable paying?
That is the ultimate question of the entire justice system.
Thanks for diving in with us.
Until next time.